I invite all of you to this session. So this is part of a series of sessions that we have been doing as per demand from the member community to bring consultants, experts who are relevant and useful for the member community to have these discussions and maybe give a forum for them to ask questions. So today we have a very relevant and useful topic which talks about the legal aspects, legal introspection about the work from home scenario that we have. So as I understand, we have, Advocate Vineet Abraham and Advocate Bindu Anthony from Brands and Bonds. As I understand, they have over 20 years of experience in the industry. So this is a great opportunity I see for the member community. So I think we have seen increasing attendance in the last series of sessions. So thanks everybody for joining us and supporting. We are also having these videos published in the GTech YouTube channel for anyone who is missing this session to see. So on behalf of GTech, I'd like to thank Dr. Vineet, Advocate Vineet and Advocate Bindu in advance for volunteering for the session, and over to both of you. Thank you.
Thank you, Harish.
Thank you.
As Harish has actually pointed out, this is one of the most pressing and relevant issues of late. The work from home, the new that understand, and there are a couple of legal aspects about the work from home. So what we are attempting over here is that even though nothing is being crystallized yet, the how legal scenario is looking at the work from home concept and what are the legal mandates that right now are some sort of governing it and what could be the possible impact. The first and the foremost thing is that as everybody would have noticed whether the work from home will actually work. So will it work is the basic question that majority of the people would be trying to address. For the past 8 months, yes, we are witnessing that it is working, at least for the IT industry. Whether it will work for manufacturing industry, it is hard to tell. However, it is effectively working for IT industry. Looking at the transition of this particular concept, earlier IT industry was very much known to this particular concept of working from home, but that time it was more of a privilege. However, now it has been transformed into an inevitable aspect. Now, adding on, the new norm is basically work from anywhere. It is not per se work from home. The concept of work from home is actually changing, and everybody is allowed to work from anywhere. Now, this has got a lot of legal connotation. Bindu, can you please mute
Sorry.
can you please mute?
Yeah.
So typically what we should be addressing over here is what you know, vis-a-vis what you should know. So what you know is basically that you can assume that the real estate cost would have come down because you are not using the facility, you are not using your office. The pollution has come down. We witnessed how Delhi was actually transformed during this lockdown period. The pollution has come down and all those things, etc. But you should also know that the domestic violence has increased to 20 to 30%. There was a report from the WTO that the domestic violence and abuses against a child has actually increased. And the sole reason for that is actually the work from home concept, or everybody is actually glued into their work, their homes. So this is a socialistic scenario that we are actually trying to address. Is it rosy over there? For few, it is very much good, but for few, it is not. If the work from home concept is going to be prolonged, there are a lot of social problems that can actually cope up, which would involve that the lack of social responsibilities and social activity, which in all perspectives could actually change the character, the behavioral patterns, and later on mold the criminal minds into a totally different segment. So there are ups and downs in this concept. As an IT industry, which is actually implementing the work from home or work from anywhere concept, it is also imperative to understand that these social objectives should also be taken care and addressed. As far as my viewpoint is that it will take another 1 more year at least, even though we are going to implement the vaccination. Vaccinations are all over here itself, but still it will take another 1 more year. So this is the context that we want to actually set up. And this is more of a socialistic objective, what I have narrated. And from here, I will take on the legal aspects. So what you should know is primarily your concern. And with respect to that, the most legal point is that whether it will be construed as a workplace. What is a workplace? From where an employee or anybody actually conducts a work could be regarded as a workplace. There's a lot of definitions for workplace, but workplace per se would mean that a particular place from which an employee or anybody actually conducts a work. Now, this is the most legal issue that could be addressed in this workplace concept, work from home concept. If your home is construed as a workplace, then all the legal obligations behind that will also be automatically attached to it. Now, whether it will be construed as a workplace is very subjective. The thought process and the dividing line is very thin. If it is construed as a workplace, then obviously the responsibility of the employer is high. And there are a couple of issues that almost all the organizations face. Particularly, it would be more better for you to actually understand how you actually manage the time. Before, when it was a physical place, all the people or the employees were actually working from logging in with their access cards or something like that, which has been recording the time. Their entry and their exit was clearly recorded. Now, here comes the legal problem. How do you actually quantify the time of a particular person who has actually worked? Of course, there are softwares to actually log in the actual times and all those things, etc., etc. But from the overall picture, is it effective? What is the productive time? Now, logging in is one of the questions. The second question would be that how do you actually analyze the performance? How can you actually understand and access that the particular employee has worked? In the work from home scenario, there is no timeline. It is not that from 9:30 to 5:30 you should be working. That concept has gone. That has been watered down. Any employee can work at any point of time. Now, if that is the scenario, how do you actually quantify the hours of a particular employee? Is it whether the employee is actually working overtime? How do you actually quantify? This is one of the most difficult questions. One of the solutions you IT guys have found out is basically logging into a particular software and all the timelines and managements, etc., which can be. It is to an extent fine, but from the overall picture, this could be a very big concern. As I was explaining, how do you actually analyze and understand the productivity and performance of a person, of an employee? The productivity would have a very big impact on the payment, performance also on the payment. So whether you will be able to say that a particular employee has worked for, say, 8 hours in a day, or as mandated as per the statute, or as it was relevant when there was a physical workplace that was the scenario. Majority of the question again comes up with regard to the eligibility of leaves. Now, leaves, if the employee is in his home, whether he is eligible for the leaves, whether the employee can demand the leave when he is in home. The answer is obvious. Since there is no specific statute which actually governs the workplace, what has been continued will continue. So the employee can apply for a leave. All the leaves that were actually available for the particular person will actually continue with respect to this particular scenario too. So there is no difference as of now with regard to work from home or office with regard to the eligibility of leaves and other stuff, all those things, etc. This could be a big issue, or there could be questions about how this. Let's take an example over here. Whether an employee can actually seek leave if he's on home quarantine. Let's say he has exhausted all his leave and he is identified with COVID-19. Whether the employer has got an obligation to grant him leave. The answer is, what would have been the case if it was for some other pandemic, not COVID-19? What would have been the scenario when the employee came over in the physical environment and he asked for the leave, or let's say he has some kind of a spreading diseases or something like that, the employee ought to have given a leave. It could be medical leave or it could be special sanction leave, whatever it is. Now there are two scenarios over here. One is that what is the criteria that to be taken by the employer if a particular person is identified as a COVID-19? The Pandemics Act specifically states that he ought to be given, or he should be given a leave, or he should be resting with, he should be taking care about his health and all those things, etc. Now, what happens in a scenario where he is actually going for a self-quarantine? If he's going for a self-quarantine, whether he should be eligible for a leave? The answer is, if he has the leaves, he can avail it. If he doesn't have the leave, if it is a self-quarantine, the employer can exercise his prudence. Now, with respect to the workplace, one and the only statute which has got a notional extension of a workplace is the Prevention of Sexual Harassment at Workplace. It says that if the employee is in any place, and if it was during the course of his employment, if some kind of a sexual harassment happens at that particular place, the employer is bound to take care about that, or employer, in other words, employer is obligated to take care about it. So you can imagine if some kind of a sexual harassment happens to a particular woman in her home, whether the notional extension would be applicable to the employer. On a strict reading of the Act, the answer is yes, the employer would be liable. Now, whether the environment of the employee was within the purview of the employer is a very subjective question. He may not have any control over it. He didn't have the time to actually even adjust the workplace of the employee. Now, if something happens to the employee over there, it is a strange issue. Nothing has been adjudicated, no cases has been reported, but this is a Damocles sword. This can happen. Couple of issues that all the employers should address in this particular scenario would be, One is with regard to the confidentiality and secrecy. How do you actually maintain the confidentiality and secrecy? Can you take up a defense saying that to your client, obviously, to saying that we didn't have the control over the environment of the employee, or it was practically impossible for us to actually create that environment, and so this particular breach happened? That is not at all a defense. You will have to bear with the penalty that will be imposed by your client if there is a breach of confidentiality. There are few case laws, or there are few pending case laws in various courts on this particular context also. So it is completely on the responsibility of the employer with regard to the confidentiality. How do you maintain those confidentiality and secrecy? It is up to the infrastructure that you can actually be enabling to your employees. There is no hard and fast rule over here, but the bottom line is that you will not be in a position to take any defense saying that the environment in which the employee was working was beyond our control. That is unnecessary. Second is with regard to the connectivity. Now, the employee can always take up a defense, or sometimes it can happen very naturally that there could be a connectivity. Right now, when we are actually speaking, there could be some kind of a connectivity issues. We will not be able to communicate. Now, how can the employer find out some kind of a mechanism in which this connectivity issue is solved or taken care or mitigated to an extent? When the employee is supposed to log in at a particular point of time and he's not able to log in at a particular point of time, whether that ought to be taken care as a leave, or is it there could be some kind of a mechanism or a means by which he will be in a position to come up with another time hours and cap up his particular work day hours, etc., etc. Yes, it is possible. Why? Basically because the shops and establishment never ever states about the time. It says about the number of hours that a particular employee can work. So your connectivity again can be mitigated. It may not be eradicated, but it can be mitigated. There are ways in which this connectivity issue can be actually taken care. Safety. Whether your employee's safety at his home is your concern. This is again a principle of notional extension of workplace. Within the connotation, in the course of employment, there is these words have got a big impact. Whether it is in the course of employment, any activity, if it is done in the course of employment, is the employer's obligation. Now, whether the safety, the same goes with the sexual harassment at workplace, which I explained in the last slide. The safety of your employee, yes, could be of your concern. How far the employer will be in a position to exercise that control is very subjective. But bottom line is the safety of your employee is still your concern. If the safety of your employee was your concern when there was the physical employment was happening, now also there is nothing has changed. There is no new loan. There is no new statute that has come to picture over here. This is something you should know. The labor laws were not designed keeping in mind the work from home concept. The work from home concept is a very recent step, or the way in which it has been done is very recent. So the labor laws were never envisaging anything with regard to a work from home concept. All the laws, all the principles, every guidelines has been issued keeping in mind that there is a physical place. There is a particular area in which the employee will come. The home was never a concept of workplace. Obviously, of like last 10 years, there are umpteen number of companies which are actually on and off provided with the gracious act of work from home. But that was very limited for a very, very, very small period of time. It was not prolonged like this. So this is right now the biggest problem. And this is what we are actually trying to address also. Keep it in mind, Nothing has been specified yet. This is one of the critical issues that you should be looking into. Do you have an agreement for work from home? Obviously, nobody would have actually signed an agreement for work from home. However, the new standing orders, which is in circulation right now, it is not yet the standing orders, it is for circulating for the discussion, states that if the employer is having an agreement for work from home concept, he can actually continue with the work from home for the period so specified by the employer. So there are two things over here which can come into light. This is with regard to the new standing orders that has come into picture, which is going to be, in all probability, will be the standing order offline. What it states is that you should have some sort of an arrangement or an agreement. It is not that you should have a new arrangement or an agreement. You should have some sort of an arrangement or agreement. And next thing is that what is the time period? Is there any time period specified for it? These are the two conditions that should be implemented within a short period of time. Now, this is something which has come. This may not have a direct connection with the work from home concept, but obviously there is a huge impact on this. What I'm speaking about is the new minimum wages notification that has come into picture. Like you IT guys were welcomed with this new notification. This is something which has been implemented a couple of days before. On this particular aspect, Advocate Bindu will be taking, or she will be providing her inputs, and I will be rejoining very soon. Over to you, Bindu. Bindu, please unmute.
Thank you, Vineet. I think I'm audible, right?
Yes, Bindu.
Yes. Good evening, all. Good evening, all. As Vineet said, this is not having any direct connection with the work from home, but this new topic, actually, the picture says itself, it's a great blow. We have received tremendous queries, and this topic has received tremendous attention during these days just because of the impact of this notification. This notification was issued by the Kerala government under the Minimum Wages Act. The notification was issued on 18th December 2020. So the effective date is really obviously 18th December 2020, not any future date. It is already in place. The government has what the government did. The government has revised the minimum wages payable to the employees. This is specifically for software, computer software industry, obviously IT and IT-enabled services. The government has revised the minimum wages and has divided the categories of employment or the designation under 9 different groups. Actually, we are looking into different types of questions popping up during these days with respect to the impact, or is it mandatorily to be complied with by the companies? These are the major questions. First one is there any clash or is there any conflict between code on wages and the new notification? Obviously, the union government, the bill for the 4 codes was already notified, but these 4 codes have not come into effect yet. So just because of this reason, the new notification by the Kerala government is still active, and we all are complied to be, or are mandatorily to be complied with this. And the next one is, what are the components of wages for the application of minimum wages, for the calculation of minimum wages? The wages, a concrete idea or concrete definition of wages has been given by the Minimum Wages Act. The wages is actually the remuneration given to the employees, either monthly or daily, inclusive of dearness allowance, basic wages, dearness allowance, and HRA. And the Act has given number of, I think it's 7 to 8 numbers of exclusions, including gratuity, bonus, or any travel allowance, or any other, what you call the festival bonus or incentives. So these exclusions are obviously there. So if you ask me a question that whether the gross wages, whether the gross salary, inclusive of basic, DA, and HRA, can be calculated as the basic or the wages for calculation of minimum wages, or is obviously basic plus DA plus HRA. This is actually the wages for the calculation of minimum wages application. And next question would be, is it mandatory for the employees or for the employers, for the management, to let the employees to know about the group? We have a separate rules under the Minimum Wages Act, Kerala Minimum Wages Rules. The rule specifically states that notice in Form 4, this is specific notice that has to be displayed at the conspicuous places of the company, explaining what is actually the minimum wages applicable to each group. That should be displayed. So as per this provision of the minimum wages rules, it's mandatory to display the groups and corresponding wages. But nowhere it is stated that we should call upon an employee and tell him that, okay, this is your group and this is your corresponding wages. Not necessary. But you have to display the corresponding group, I mean the groups and corresponding wages in a particular form, that is Form 4. Next, a question is there any correlationship or is there any connection between the experience, years of experience, and minimum wages? See, minimum wage is actually notification. As per the notification, there are 9 groups and corresponding wages, and there is a scale for wages. First one is the basic wage, and the notification itself says for 5 years there will be an agreement, there will be an amount of an agreement for 5 years, and then the second figure, that means the second minimum wage figure is there, and after that again for 5 years there will be another figure of increment, and after that a final figure of minimum wages. So there is a scale starting from minimum wages, then increment, then another figure of wages, and then again an increment for 5 years, and finally lastly the final figure. This is actually the scale as per the notification. So suppose if an employee is coming to your office, joining your office as a team leader, and the minimum wage as per the minimum wages notification, as per the last notification, suppose the minimum wage is 10,000 rupees or 20,000 rupees, say it's 20,000 rupees. And the notification states that there is an increment of 500 rupees. For an example, an increment of 500 rupees for a period of 5 years. So after this 5 years, his salary, his minimum wage or his minimum salary will be 30,000. So for a new employee, for a new joinee, your minimum salary to be given to the minimum wage to be given to the employee is the first figure. And if your employee is having 5 years of experience, then definitely his salary would be the second figure. So this is actually the scale given by the government for the calculation of minimum wages. And this is also specifically stated, explained in this particular notification. And next, what about the daily wages? Some of the employees are getting daily wage on a daily basis. So you can calculate this minimum wages on the basis of the minimum salary divided by 26 days. Then you will get a figure for the minimum wage for a day, daily wages. Then suppose another question would come up. If you are giving higher amount of salary than the minimum wages, then if such employee is entitled to continue the higher wages or the minimum wages prescribed by the notification. Obviously, the answer is if an employee is gaining or if an employee is receiving a higher amount than the higher salary than the minimum wages prescribed in the notification, he is entitled to continue to get the same higher wages, not the minimum wages prescribed in the notification. And there is also another what you call another provision in the notification, that is dearness allowance. Dearness allowance is also a part of basic wages. Dearness allowance is to be calculated on the basis of the consumer price index, specifically for each district, designed by the Ministry of Economics and Statistics. That's also another thing included in the another provision included in the notification. So this is what you call a new notification, and the date of effect is 18th December 2020, and all the companies, all software related companies are mandatorily required to be complied with this notification. And if you have any queries, you can chat me or you can contact me later. Thank you, Vineet. Over to Vineet.
Yeah, thank you, Bindu. I would like to add one more point over here is basically this notification is only for the IT industry. Keep it in mind that the notification has not been brought for any other industries. So there was the government's notification also says that it was in circulation for quite a period, and after that only this was actually finalized. So if the IT fraternity feels that this is a bias against them, or this is discriminatory, or the wages stipulated over here is high, there could be some kind of recourse. The government, you can alert, the GTEC can be a platform in which you can actually alert the government about this kind of a discriminatory element, or what is the rationality of this particular minimum wages, or how the wages has been set. Can be questioned, or through a diplomatic channels on the stand, and otherwise if that doesn't actually work, then it could be a judicial process in which you can alert the High Court and see how this notification can be looked into. Having said that, the point that what I wanted to make it clear is that we have been receiving a lot of queries from our own regional clients and other IT clients about how to implement, whether you should implement this thing, or is this looks a bit extended figures and all those things, etc. It doesn't work for the IT companies, etc. So we got all sorts of request explanatory notes being sent to our clients and all those things, etc. However, the point is basically that we too are also helpless on the point that this ought to be alerted to the government in some or the other way of the memorandum, or otherwise through a judicial process. That is the only way in which this, if at all, if the IT fraternity feels that this minimum wages has been set at a very higher pedestal, then that's the only recourse that at right now what we can have. Next, basically, is that this could be more of from a general perspective rather than a specific perspective, like force majeure. Many people would have heard about this particular word of late, about the force majeure. Like the force majeure simply means the act of God. So it's that when both parties are unable to do because of an intervening situations, like which is beyond their control. That is what force majeure in simple terms means. So whether force majeure, that particular concept can be applied in this particular scenario when for a general contractual purpose, or when there is a key contract that is going to happen, or if you are not able to perform those obligations, etc. Whether force majeure can be implemented on the basis of this COVID-19 situation. And now that is again very subjective in nature. The question is whether you are in a position to implement those things or not. So what is the inability of you not to perform the particular obligations? It has to be mandated. COVID-19 itself, during last year, during when it was started, when the lockdown and all those things started, there was an umpteen number of contracts which were invoking all this force majeure and all those things. Right now, globally this particular lockdown or pandemic situation has been relaxed to a great extent. Obviously, there are new mutants and all those things, etc., coming up, and the new versions are coming. And we don't know how it can be. Whether there is a lockdown in the near future is something which is again looked into. But force majeure particularly says that when both parties are not able to perform. IT industry, from the perspective of an IT industry would be one of the industries in which this particular non-performance was not such a serious issue, because of late, to be very frank, today's newspaper ran a column which said that the Infosys and Wipro actually had a profit during the last quarter. And so that typically means that yes, the IT companies are able to deliver it. So force majeure will not simply come to your rescue. Force majeure will come into your rescue only if you can actually prove that you were unable to perform the particular thing and it was beyond your control. COVID-19 per se cannot be right now taken as a defense. That's the end point that I shared, what I wanted to make on this. Now, this is again one of the key concerns about contract execution. Today's newspaper also ran a particular point that TCS is going to actually hire a lot, or the hiring of the new employees has increased to a very great extent, or it is back on track. Now, how you can actually execute, like if you want to actually engage an employee, you want to hire a new employee, how you can actually employ the particular person over here. We know that usually everybody comes over there and sits over in your particular HR room and all those things and makes a signature of this. So the physical signature right now, if the work from home concept is what we are actually discussing, is the scenario, the physical signing of the contract cannot be implemented. Now, is there anything specific statute which actually relaxes that? As I said earlier, nothing is there. There is no specific statutes. In India, the contractual principles are very clear and simple. One is that even an oral contract is a contract according to the Indian contract law. Now, if you have how it is actually done is that when you have a written contract, the legal terminology itself is that it is reduced to writing. So you are reducing it to a writing and then signing a contract. Now, oral contract is a contract and a written contract is also a contract. Now, in India, the place of execution and physical signature is one of mandatory conditions. Now, in the current scenario, whether you will be able to get a physical signature of your employee or any contractor is very, very difficult. Now, how is there any way out in this particular scenario, keeping it legally? And obviously, under the Indian law, it ought to be on a stamp paper. Apart from the appointment letter, all other agreements and other strings, etc., even an NDA ought to be on a stamp paper. Now, getting a stamp paper is difficult. Getting the particular person to sign physically, come over to the particular place and get the signature is difficult over this scenario. How you will be able to overcome this thing? It may not be 100% correct, but still what you can do is that you can get the signatures, ask your employee to take a print of it or something like that, ask them to sign it, scan it. The CAM scanners and all of the scanners are there over there, so you can scan over it, ask them to sign it, and both the employer and employee should actually send out an email corresponding to their signatures and say that ultimately a follow-up email which says that yes, both persons are actually agreed. How it will help is basically the Indian Evidence Act also states that all the electronic communications are valid before a court of law. So this is how you are. Have you physically signed it, or whether the place of execution is clear? These are the two scenarios over here. How to mitigate? I'm not saying that it is 100% correct, but right now what you can actually do is that both persons sign over there, scan it and send it through emails over there, and then a follow-up email which says that yes, there is an agreement by both persons and all those things. This is signed and duly signed and executed. It is not, if it is not an employment contract, it is not still stamped. So there is a stamping is actually an irregularity. If the non-stamping is an irregularity, stamping is a regularity. If you have not stamped it, what the law says is that you can impound the particular contract by paying 20 times of the stamp duty that you ought to have paid, and then present it before a court of law. Now, presenting before the court of law is the secondary aspect, but to make it legally correct, this is how you can actually manage. This is again, I'm saying that this is how you can actually manage the particular scenario. It may not be fully correct, but it will actually give up one of the main criteria. It is valid as per the Indian Evidence Act. So this is something which everybody should actually try to implement overhead, because this is, if every work from home is going to be there and your interviews and all those things is going to be in this fashion, then definitely what can be done is only electronic records. Another point that you should be taking into consideration is the data protection. Nowadays, IT industries, the data protection is one of the key. Off late, everybody will be very much well aware about the WhatsApp policies and other things, the Springer issues that we had, all those things, etc. The data protection is one of the most important criteria. Confidentiality of it may be your concern with regard to your employment point of view. From your client perspective, the data protection is one of the most important element. And India has actually circulated a bill like long back 2019, and last year it was not actually implemented, or it is still with the standing committee and all those things, etc. It is heard that this personal data protection bill will be passed during the coming sessions, parliamentary sessions. If that is the case, it is a welcome move, because the data is going to be the next big money maker. It's already is the big money maker. What sorts of data is all the data protection bill is in the pipeline, and this is something which IT fraternity should be looking forward, and like you should be able to know what are the nitty-gritties involved. Let's say somebody actually creates an e-commerce website or something like that. All these the data protection laws will actually come into play. Your website simply has cookies, then definitely again data protection act will come into play. If you are collecting the data of Europeans, obviously you will have to abide by the GDPR guidelines and all those things, etc. So that's a totally different scenario, but still this is something which you should be taking care during this particular COVID scenario situation. Now, we have stated a lot of problems. So the ultimate question, like everybody would be, I can tell you 1,000 number of problems over here and all those things, etc. But if you don't have a solution to it, then there is no point of actually having a question altogether. Now, what could be, as I said earlier itself, whether there is any specific statutes to it or whether there is anything, nothing. But the government is actually trying to guidelines. One step is basically the standing the standing orders which has been in circulation, and slowly the government would try to make some changes, provided this work from scenario is going to stay for a long period of time. Right now, if few of the companies, let's say TCS has already declared during when the pandemic situation was, even if the pandemic is not there, they are going to have this work from home to continue. And many number of IT companies found it in their favor to continue with this particular work from home concept. So we also have identified few situations, whether the workplace, whether it can be quantified as a workplace. If there is a workplace, what is the liability of the employer, whether how the POSH Act would actually come into play and all those things, etc. So typically these were the problems. Now, is there any solution to it? There is a very there is only one and single solution to it, and that is basically to have a work from home policy. Now, how does that work? You should actually have a work from the institution should, or the organization should have a work from home policy, which actually enumerates all these concerns, like what would be your leave, or how your connectivity can be an issue, what is your working hours, all these situations, whether, and it would help the employer to actually mitigate the risk about that he doesn't have, or he can state that he doesn't have actually have the control over the particular environment also. So these are the way in which, to an extent, the employer can mitigate the risk. And also from the employee perspective also, he also understands that if I don't have a connectivity on a particular time period, I would be still in a position to actually complete my work, provided there are conditions. So uh, and frankly speaking, there is no standard work from home policies, all those things like that. You will have all the nomenclatures and all those things uniform, but the work from home policy should be unique for each and every institution, depending upon their behavioral, their experiences. It may not be like if you are call center service, if you are providing call center services or something like that, the work from home can work to an extent, but it may not be practical for you to actually carry out from a long run. So it depends upon each and every industry. Now again, if you have a strict environment,
I think Vineet has lost his connection. He'll be joining now.
Okay, Vishnu. You're talking on mute.
Advocate Bindu, in the meantime, you can carry on. So Vineet will be joining soon. You're on mute, Bindu.
Yes. I think this is actually the last slide of our session, and Vinitha has already given a complete, a concrete solution for the entire problems or the entire queries or the questions we have put forward. And this is only the solution, that is work from home policy. We can draft a unique or a concrete work from home policy for each and every establishment. That should be a tailor made, because one's establishment's attitude or work from I mean the work environment or the policies or the, what do you call, the attitude of the employees and employers are entirely different from others. So it should be tailor made, it should be specific and unique for each and every establishment. So this work from policy should have a clause for confidentiality, should have a solution for what you call the monitoring the working conditions of an employee. Everything will be there. So the complete solution is obviously work from home policy. I think we need this joining.
yeah, I have joined.
Yeah.
Sorry for that connectivity
Yes.
problem that we were actually discussing on that.
Yes.
So that was basically what I had to actually sum up, and the solution could be more of the work from home it's policy itself. Now, one second, whether I can. I was almost at the end of the. One second, I'm going to share my screen. One second. I think, yeah. So this is particularly the answer for almost all the problems that we can actually we have over this particular period of time. So remember that there is no specific statutes and all those things, etc. And trust this was actually helpful for this thing. We will be taking in. We have been given few questions to address. A few questionnaire was actually given. So I will try to attempt a couple of queries which has been specifically pointed out. And one of the question was that is there any documentation to be maintained when somebody is allowed to work from home? I believe that you would have got the answer. Per se there is no requirement, but the draft standing rules obviously states that if you have an agreement with your employee and also which specifies the timeline, then obviously that that is mandated. So it would be the next norm that you should have an arrangement with your employee. That arrangement need not be an agreement itself, but it can be which actually stipulates a condition which says that this is the timeline that we are actually looking in, and we are allowing you to work from home from this period to this period, obviously that. And then next question is with regard to will there be a formal work from home policy by the government and the related labor law changes? So again, I believe that we have attempted to answer that also. There is no formal policy formulated by the government till date. But however, there is a huge discussions that is going on. NASSCOM actually had sent out a report to the government about the changes that they feel that the IT industry should cater to, or there are how the labor law and the income tax laws and all those things should be done. So there are a couple of recommendations by these kinds of bodies, like NASSCOM included. NASSCOM had actually sent out this report last May or June or something like that, but the government has not yet come up with any concrete plans on how to implement that. However, if the work from home is going to be staying over here, irrespective of the fact that the pandemic is there or not, obviously the government would formulate a few guidelines on work from home. And another question was with regard to any amendments on the leave procedure for working from home. How to do an effective background verification of the candidate while hiring them remotely, and especially for outstanding candidates. Okay. Now, with regard to your first question, whether any amendments on the leave procedures, right now there is no amendment on the leave procedure. Nothing has been stated on this thing. How the leave will be governed will be in the exact fashion in which it was actually being governed. There is no specific whether the employee is eligible for all the leaves. Yes, the answer. One of the slides I tried to explain that itself, that whatever they were actually eligible for till yesterday, they will be eligible for tomorrow also. So there is no clear-cut unless and until the government again formulates some kind of policies and other things, the leaves and all those things, etc., has to continue. With respect to your next question, unfortunately, again, if you have some kind of a means and the mechanism to actually conduct the background verification, obviously it can be done within the protocols of the COVID protocols and all those things, etc. Otherwise, the self verification or self attestations or something like that, which can be thought about. Again, another apart from the criminal records can be actually found out from the court by giving or there are means to understand whether a criminal petition is filed between. You can ask for a sworn statement. Again, I'm actually extending to address your query. You can get an affidavit from the employee stating that there is no criminal records or something like that, which ought to be notarized by a notary public. So it's again a far-fetched extended aspect, but still the employee can actually mandate for such a kind of a sworn statement or something. Again, another question was with regard to flexible work arrangements as a permanent work arrangement. Can we reduce the salary benefits of these workers? Obviously, Bindu would have stated that what is your new norm is actually the Minimum Wages Act. So within those corners, if you have any leverage to actually increase or decrease or whatever it is, etc., you have all the privilege to do that. But beyond that, there could be your hands are tied. Like working from home doesn't mean that you can reduce the salary. No, that doesn't actually per se give you any right over that. Another question was, does the current label comment on the basic facilities provided during the work from home scenario? Yeah, that's something which who has got the obligation to actually provide the infrastructure? That's one of the key questions that can be addressed. Whether the employer has got any obligation to provide the infrastructure facility. The answer is yes, because if from a physical point of view, the infrastructure, the work environment, the computers and all those things were actually given by the employer himself. Now, when they actually transform that into a work from home thing, it doesn't mean that that obligation is eradicated. Only thing is that it was a work arrangement between the employee and the employer, that the employee would use his infrastructure and facility. Now that would be the basic facility, like the way in which it can be actually done. For example, the internet needs to the employer can actually reimburse the internet payment or the telephone connectivity, or if they want to have a computer and all those things, etc. So typically, to answer the question, the infrastructure ought to be provided by the employer. Employee doesn't have any per se obligations. Obviously, this can be extended to a bit here and there. But however, the understanding is that the facility, infrastructure, environment has to be provided by the employer. That has got a big implication. It is not that whether the employee can ask for that. I want to have the particular chair in which I used to sit. Can I get that kind of a chair and the table and all those things, etc., etc. It's far-fetched over here. Whether he is eligible, yes, eligibility is also there, and obviously the impossibility is also there. It is not practically possible for the employer to address each and every concern over that. But with regard to the net connectivity, the computers and the other infrastructure that has to be provided, yes, the employer ought to have provided. And then, so another question, I wish to know the legal responsibility of the employer to provide annual leave as per the factories or shops and establishment while working from home. Again, I think we have addressed that particular question also, like with regard to this, the annual leaves and all those things. There is no change at all in these annual leaves and other leaves and eligibility of these leaves, etc., etc. It will continue as it is, etc. And there is one question: are the workers entitled to get compensation based on the workman compensation policy when working from home? So it's an interesting question. It has got multifold aspects of it. The first and foremost is that the acceptance of the fact that whether the home is a workplace. So even though I had actually narrated that in the first instance, it is not a settled position that it is a workplace. The POSH Act is the only act which actually extends this notional extension of the workplace. Apart from that, no other act per se envisages a home as a workplace. Now, if it is a workplace, obviously the answer would be yes. The answer would be yes. He would be entitled to the compensation. So that would mean that if something happens in his environment where the employer cannot have or exercise any control, still the employer would be liable. Far-fetched, but still, from a legal perspective, if you ask me to answer it in yes or no, the answer would be yes. It would be. Again, one more condition is that the Workmen Compensation Act should be applicable for that such a company or industry. If it doesn't actually apply, if the Workmen Compensation Act or the Employee Compensation Act, which has been Workmen Compensation Act has been changed to renamed to Employee Compensation Act. It also states it also actually has got the applicability. The applicability is subject to few industries. So if your organization falls in that particular industry, then obviously the act will apply. In that case, yes, the answer would be yes, you need to actually give the compensation to the employees. I think I had covered more or less covered the queries that have been sent across to me, and
Yeah, Vinith, there were a couple of queries which has been raised by participants in chat box.
sure,
So if you want, I can read out a couple of that.
yeah,
Shall I?
sure. I'm actually trying to address that.
Okay, okay, fine.
Okay, first question somebody has asked is the payroll processing through WPS is mandatory. WPS is there, so wage protection system is the only way in which, like as per the Kerala, this thing wage protection system is still the norm. So you ought to pay it as per the wage protection system itself. Is work from home policy to each establishment, or should it be different for each establishment? I believe I have actually tried to attempted to explain it here. It depends upon what is the requirement of each and every establishment. So it would be the few practices would be unique to few of the establishments. So it depends upon each and every the way in which they want their employees to work, or what is the timeline. And few employees would be working on US timings or European timings or something like that. So what is the work arrangement that everybody is having, and somebody is actually forced. It is not the environment. Your spouse is actually sleeping over there and you're supposed to work, so it can create a lot of problems and all those things, etc. But still, yes, the work from home policy can actually try to cater to that particular. So it depends upon each and every organization. Can I work from abroad? As I said, the norm is not work from home, it's work from anywhere. So it doesn't actually mean that this thing. But when you are actually,
It's 4 o'clock.
when you are actually stating that when an employee is actually working from abroad, there are a few other stipulations also needs to be taken into account rather than simple work from home. If an employer requests for there's a lot of queries. If an employee requests for work from home for personal reasons or for convenience, should be allowed. I believe I have answered. For you to specifically answer your question, the leaves which were prevalent earlier will continue. So the question is that whether you would have approved those leaves. If you would have approved those leaves, he ought to get the leaves. Now, the only situation different over here is if he's identified as a COVID patient, then it is mandatory that you should actually give it.
Yes, next question. I think I could answer, Vinith.
Yeah, go ahead.
Yeah, how should the company be displaying the Form 4 mentioned? Can it be via software, or it's mandatory to post in somewhere as in notice board? What the rule states is that it has to be displayed at the conspicuous place or at the front office of the company in Form 4. That's what actually the act says. But during considering these COVID situations or these work from home situations, we can interpret it as through a software or through something through the company software. But what actually the act states, it's in Form 4, but it has to be displayed at the conspicuous place.
Okay, then somebody has asked, any specific law while we are working remotely in India for a foreign country? No, there is nothing, no specific laws has been there yet. So then there are a lot of, I'll try to address what is relevant.
Next, another question. What is the minimum wage for a software engineer as per the Kerala minimum wages notification? The software engineer would definitely come under Group D, I think. So you can, I think the minimum wage as per Group D is 17,516. That is the minimum wage for a new joinee. And there will be some increments as per the notification, and we can increase that salary on the basis of the experience of an engineer. So software engineer would definitely come under Group D.
Okay, then there was something that can an employee be allowed to work from outside India temporarily upon his request? Is it legally necessary to report the same to the employer? Like, Again, it is a gracious act. He can be allowed to work from abroad. But there are other implications, all those things, whether the per IDM has to be paid and all those things, etc. If he's actually outside India, is also to be taken care. But the work from home policy can address to that to a great extent. But it is completely up to the discretion of the employer to allow this request on a temporary basis. It may not be on a permanent basis. And second question, is it legally necessary to report the same to the employer? The answer is yes. It would be, the employer should actually insist upon reporting such and such things. Why? Basically because the personal accidents or something like that, insurance or something like that, all those things, etc., also needs to be addressed apart from the work per se. So it is always taking into account only all these aspects that the employer should permit an employee to work from abroad. But there is there is nothing legally objecting, because the work from anywhere is the norm, not work from home. So it need not be the home itself. Then there's some question about what about the scope of new wage code effective and percentage of new rules, etc. Okay, see, the wage code is going to be implemented and with effect from April 1st of April. That's what my understanding is. That so scope of new wage code. So a lot of things has been changed. It's actually codifying around a lot number of statutes, and there's a big definition. The dividing line between a worker and employee has been reduced to a lot of extent. So there is a lot of aspects that is going to come into picture with regard to the wage code also. Yeah, definitely. Somebody has asked, I think that's the last question, with regard to the model standing orders have come into effect already. It is applicable to establishment and the model standing orders is not yet implemented. It is going to be implemented. It is in circulation. A couple of days or something like that. It's just 15 days. It's available, but it is not yet implemented. Work from home has made employees to use their own resources, especially in industry. If the employee claims reimbursement for such expenses, etc., employees to consider it. Again, depends upon your work from home policy would actually be the Bible for this, all these queries and all those things, etc. If that is an expense, that is an expense. The infrastructure, as I said, the infrastructure ought to be the obligation of the employer. So if he actually claims all these things, etc., then nothing legally has been stated. But if he can prove that his usage before work from home was this and after work from home was an exorbitant amount, obviously he would be entitled, or he can actually press on the charges. I believe we have tried to address almost all the questions, and if at all, I believe the session was useful. At least there could be some kind of a takeaways for whoever has joined. If there is any other things, or otherwise we would be winding up. Vishnu, over to you.
Yeah. Thank you, Advocate Vineet and Advocate Bindu, for this informative session, and thank you all for participating in this one. And thanks, Vineet, for addressing the queries which the participants have put up, and this was a need of our session. And I will be sending you all the recording of this session. And if you have any further queries, kindly write it to me, and I will directly connect you with Advocate Vineet. And after this session, I'll be sending an email with the feedback form also. You can just respond to that feedback form. So how was the session, and how was the question and the Q&A sessions and all. Okay. So Harish, do you want to say something?
No, I think we have already over time. So thanks a lot, Advocate Vineet and Advocate Bindu. This was a really useful session. I think this is one of the sessions where we hit record number of participants. So that shows that people are keen about what we discussed today. So once again, thanks a lot, and appreciate your initiative here.
Thank you.
Thank you all.
Well.
Thank you all. Thank you so much.